आगे। राइस हो गया। जाइए। चल रहा गिलास में पानी दे दोगे फटाक से। Hello, am I audible? Hope I am audible to everybody. So, let's continue with our live classes, and today we have come up with another topic which is very important for civil service examination, whether it be prelims examination or the mains examination. The topic of citizenship, which has been in news from a long time and is already in news now because of the recent developments that the Constitutional Amendment Act has to be implemented from now on. So let us delve into the basics of citizenship, what citizenship is, and how the citizenship is provided in India, and what is the difference between the citizenship which was provided at the commencement of the Constitution and after the commencement of the Constitution. Means during when the commencement of the Constitution began, means the Constitution commences. It was on 26th of January 1950. So on 26th of January 1950, the Indian Constitution commenced. Who were the citizens of India at that time? And later on, when the first act was made in 1955, the Citizenship Act of 1955, who became the citizen of India after that, and what changes does it bring into the citizenship aspects. So let us start with the word citizenship. So is the word citizenship defined anywhere in the Constitution? It is not defined in the Constitution. Citizenship is nowhere defined in the Constitution. It only gives a skeletal framework, sort of provisions about who would be the citizen of India when India starts functioning under its new Constitution. And the future aspect of citizenship were left to the parliament, the elected parliament, which will pass law and make law in order for people to acquire citizenship, clauses for termination of citizenship, cessation of citizenship, so on and so forth. So there were several basic articles in part 2 of the Constitution. In part 2nd of the Constitution, under Article 5 to 11, where these things related to the citizenship is defined. Again, they tell about that citizenship in India at the commencement of the Constitution. This is important to understand. So who were the citizens of India on 26th of January 1950? The provisions in these articles talk about those whoever be the citizen of India from the 26th of January 1950. Under several articles such as article number 5, article number 6, article number 8, several conditions for registering yourself or by migration or by domicile, conditions have been provided under which a person can become the citizen of India. So for example, let's come up with article number 5. If we see, there were 3 ways in which you can acquire the Indian citizenship at that point. One was domicile, second was through migration, and third was through registration. Domicile, migration, and registration. This debate on citizenship went on for too long in the Constituent Assembly. When the Constituent Assembly was drafting the Constitution of India, no other provision has exhausted so much time of the Constituent Assembly than the provision of the citizenship in India, because it tells about the importance of citizenship. What privileges does a citizen have within a country? If you see that, you will understand the importance of citizenship. A citizen in India can enjoy the fundamental rights. Some of the fundamental rights have always also been provided to non-citizens, such as the equality before law or right to life, because that is important. If somebody comes to India who is an alien, that simply means who is not the citizen of India. So we have to give some protection to him, but we cannot allow the right to freedom of speech, or we cannot allow them to profess, propagate and practice their religion in whichever way, shape and form they want. So there are several restrictions as far as the fundamental rights go on the non-citizens, but to the citizens of India, all the fundamental rights are available. Fundamental rights under Article 15, under Article 16, under Article 19, right to freedom, all these important rights which are very much necessary for the evolution and to reach for the human being to reach its optimum stage, that has been given to the citizens of India. So it becomes very important to define the parameters through which a person can acquire the citizenship in the country. Along with the fundamental rights, the citizens also have to follow the duties. This is important. The duties are not there for foreigners or the aliens who are living in the country or the non-citizens who are here, but the citizens have to follow some duty. Along with it, citizens are registered in the electoral roll. They are eligible to elect the government. If they are registered in the electoral roll, you can vote. If you are the citizen of India, this is one of the condition. If you are the citizen of India above 18 years of age, you will be in the electoral roll and you can elect your parliamentarians, your legislative assembly, your municipality और your local government, local पंचायत members. तो ये जो वोट देने का अधिकार है, ये भी सिटीजन्स को दिया गया है, ये नॉन सिटीजन्स के लिए नहीं है. इसके अलावा देयर आर सेवरल ऑफिसेस जहां पर आपका इलेक्शन हो सकता है, वेयर यू कैन बी इलेक्टेड. व्हाट आर दोज ऑफिसेस? प्रेसिडेंट, vice president, these offices, the governor of the state, these offices only if you are the citizen of India, you can be appointed or elected to these offices. You can also fight elections of member of parliament, of member of legislative assemblies. All these privileges are given to you when you are the citizen of the country. So that is the reason why citizenship has taken maximum time or the maximum debate in the Constituent Assembly, and even when they have given so much time in discussing this aspect, it was at the end left to the parliament to decide, because the consensus was not made and only provisions relating to the citizenship at the commencement of the constitution was written down in the Constitution of India. तो इतना ज़्यादा दबाव था हर एक सेक्टर से कि किसको सिटीजन बनाएं किसको ना बनाएं, कि बहुत लंबा डिबेट होने के बावजूद भी उन सबको फ्यूचर पार्लियामेंट पे छोड़ दिया गया. बहुत से मेंबर्स थे कॉन्स्टिट्यूएंट असेंबली के जो बोल रहे थे कि फ्यूचर पार्लियामेंट पे क्यों छोड़ा जाए, हम यहाँ पर बैठे हुए हैं, यहीं पर हम अपने प्रोविजंस बना देते हैं सिटीजनशिप के. बट कुछ दूसरे ग्रुप थे, कुछ तीसरे ग्रुप थे, कुछ चौथे ग्रुप थे, ऐसे कई सारे ग्रुप थे जिनकी अलग अलग डिमांड्स थी और लेजिबल डिमांड्स थी, लेजिटिमेट डिमांड्स थी, अननेसेसरी डिमांड्स नहीं थी. तो इतनी उलझन हो रखी थी उस समय, that they have to leave this whole topic on the future government to decide who will be the citizen of India. और उस समय उन्होंने एक स्केलेटन तैयार कर लिया, एक ढांचा तैयार कर लिया सिटीजनशिप का, जिसमें बेसिक रूल्स एंड रेगुलेशन फिट कर दिए, सच एज देयर कैन नॉट बी अ डुअल सिटीजनशिप. ये बात आर्टिकल नंबर 9 बोलता है कि if you acquire the citizenship of any other country voluntarily, what will happen? You will cease to be the citizen of India. तो ये सारी चीजें ही कॉन्स्टिट्यूशन में लिखी गई कि भाई 26 जनवरी 1950 का दिन और उसके बाद भारत का नागरिक कौन होगा, यही बात, सिर्फ ओनली दिस थिंग was written down from article 5 to 11 in the constitution of India. 1950 के बाद जो कुछ भी होगा उसके लिए पार्लियामेंट एक लॉ बनाएगी. सो पार्लियामेंट केम अप विद अ लॉ इन 1955. बहुत लोगों ने क्रिटिसाइज करा कि भाई 5 साल आपने लेट कर दिया. तो फिर जो 1955 का एक्ट है उसके अंदर भी कुछ प्रोविजंस जोड़े गए कि इन 5 साल में अगर कोई अपनी सिटीजनशिप नहीं पा पाया या फिर 5 से लेके 11 जो आर्टिकल्स हैं उनके अंदर इफ somebody was unable to be registered as the citizen of India, then they will have some remedy in the 1955 act. So these are very complex and broad provisions of the citizenship of India, and this is very important topic, not from the exam point of view, not from the exam point of view, but from the point of view of the functioning of the country, because once you are the citizen of the nation, only then you can enjoy maximum of the fundamental rights. Okay, and fundamental rights are needed for your growth. There is no concept of doctrine of waiver in India. If you would have heard about this doctrine of waiver, ये क्या बोलता है doctrine? This doctrine says that a person who has been given the fundamental right can waive it. Waive it means can leave it. You may come up and say, I don't want these fundamental rights, you can keep it. That means I do not want the right to go to the court if any of my fundamental rights have been infringed or abridged. But this concept, it is not practiced in Indian parlance. One of the judgment of the Supreme Court says that there is no right of the waiver of the fundamental rights is available to the Indian citizens. Although this is a very important doctrine in the United States, because they do have the right to waiver, they can waive their own fundamental rights, but in India we cannot. But still, citizenship and the importance of citizenship through all these elements which we see in the constitution, it becomes very important to define it nicely, and that is the reason you have seen so much of a hue and cry when the Constitutional Amendment Act recently was passed in 2019, and thereafter there were disturbances in the country and it was termed as anti-secular, it was termed as against one particular community. So let's delve into the different articles which tells us about the citizenship at the commencement of the constitution. So let's understand how you can become a citizen through domicile. If you are born in India, if either of your parents were born in India, or if you are ordinarily residing, in India for more than 5 years before the commencement of the constitution, that means before which date? 26th of January 1950. before this date, if you were residing in India for more than 5 years, then through domicile you can get the citizenship of India. Okay, see here, domicile means residence, and domicile, there is a difference between domicile and residence. Domicile is equal to residence, आप जहाँ पे रह रहे हैं, that is equal to domicile. Now this is what is the normal understanding of the word domicile, but this is not the case. Supreme Court in its judgment has told that domicile along with residence also means the intention to make India their own country. If this intention is lacking, there is nothing like domicile. If you are living in India, if you are residing in India, let's say from 7 years, but you consider your motherland wherever you were born to be your real home and you do not intend to become the citizen of India, then you cannot get citizenship based on domicile. There were many cases that time where the people from England or from other countries were living in India for more than 5 years. But they did not get the citizenship because they did not intend to become the citizen of India, and at a given date in future they would return back to their country. So they just wanted the citizenship of India for some time so that they can get all the benefits of being the citizen of India, and they can live according to their own will till whichever time they want to live, and then they can leave for their own countries. So to reduce such cases, the definition of domicile, the interpretation of domicile was done by the Supreme Court, and it said along with residence you need to have intention to be the citizen of India, to live here in this country. So it is an important element, domicile. If you are born in this country, if your parents, either of your parents are born in this country, and if you are residing in this country, ordinarily residing for more than 5 years, you will get the citizenship of India by domicile. और ये कब की बात हो रही है? ये अपन की बात हो रही है उस समय की जब कॉन्स्टिट्यूशन का कमेंसमेंट होता है, मतलब 26 जनवरी 1950 के दिन से और उसके बाद से कौन कौन भारत का नागरिक होगा, उसके ये प्रोविजन। अगर आप भारत में पैदा हुए हैं, अगर आपके माता पिता में से कोई भी भारत में उनका जन्म हुआ है, और या फिर आप किसी बाहर के देश के भी हैं और आपका जन्म भारत में नहीं भी हुआ है, आपके पेरेंट्स का भी जन्म भारत में नहीं हुआ है, पर फिर भी अगर आप मोर देन 5 ईयर्स से इंडिया में रह रहे हैं with the intention to make India your own country, with the intention to get the citizenship of India, then you will be provided the citizenship of India. ये कब की बात है भाई? 26 जनवरी 1950 के दिन और उसके बाद से कौन कौन भारत का नागरिक होगा, ये बात उस समय की है, उस समय की है। ये सिटीजनशिप जो है वो तो उसी समय शुरू हुई थी ना। अपने जो पेरेंट्स हैं और जो ग्रैंड पेरेंट्स हैं और जो उनके पहले की जो जनरेशन है, उन सब ने वो देखा है कि देश आज़ाद हुआ, उसके बाद संविधान बना और उसके बाद संविधान लागू हुआ। तो जब ये सब चीज़ें चल रही थी उस समय से लेके अभी तक, ये इंडिया के सिटीजन्स ही तो हैं जो यहाँ रह रहे हैं। तो इट वॉज वेरी इंपॉर्टेंट एट दैट पॉइंट टू डिसाइड, in 1950 it was important to decide that who will be the citizen of India. That is why these decisions were made. इसलिए ये प्रोविजंस लाए गए कि भैया डोमिसाइल के थ्रू या माइग्रेशन के थ्रू या रजिस्ट्रेशन के थ्रू आप भारत के नागरिक बन सकते हैं, है ना। तो डोमिसाइल के थ्रू, if you're born in India, either of your parents are born in India, and if you're residing in the country for more than 5 years, you will be considered the citizen of India. तो मैक्सिमम लोग तो इसी के अंदर आ गए थे। If you see the whole of India, maximum people were citizen of India just by the virtue of being born here or by virtue of their parents being born here. Second आता है माइग्रेशन. ये बड़ा इंटरेस्टिंग है, माइग्रेशन. तो भाई कुछ लोग उस समय थे जो भारत से पाकिस्तान चले गए थे. कुछ लोग उस समय भारत से पाकिस्तान चले गए थे. कुछ लोग ऐसे थे जो पाकिस्तान से भारत आए थे. There were several people who migrated to Pakistan from India, and there were several people who migrated from Pakistan to India. तो जो लोग अंदर आ रहे हैं, whoever is coming to India, of course you want to make them the citizen of India. But what about the person who has went back, who have gone to Pakistan? Some of them have also came back. This is important. So it is important to understand these two conditions. There were two kind of people. There are two segments of people who were coming to India. भाई citizenship तो हम Indians को ही दे सकते हैं ना जो इधर हैं. The land which was then considered Pakistan, we cannot provide citizenship to them, and whoever is willing to go to Pakistan, their country, Pakistani government will give citizenship to them, not Indian citizenship, not the Indian government. So the issue with the Indian government was whoever is coming from Pakistan, we need to give them citizenship. So there were two kind of groups. One was who were directly migrating from Pakistan to India, who were coming from Pakistan to India. Second, who left India for Pakistan and then afterward decided to come back to India. ये दो ग्रुप हैं. लेकर वो भी आए हैं जो पहले पाकिस्तान चले गए थे, ले दे के वो भी वापस आ गए हैं. तो ये दो ग्रुप हैं. दोनों इंडिया में आ रहे हैं, दोनों को सिटीजनशिप देनी है. दोनों माइग्रेशन कहलाएगा, है ना. सो दोनों माइग्रेशन कहलाएगा. तो ये क्लॉज क्या बोलता है? आइदर ऑफ योर पेरेंट्स आर बोर्न इन इंडिया or if you were born in India and if you are migrating from Pakistan to India, then you will be given the citizenship of India. Okay, but यहाँ पे कुछ थोड़ा सा ट्विस्ट है. अगर आपका माइग्रेशन 19th of July 1948 के पहले पहले है, that simply means 19 जुलाई 1948, 19th of July 1948 के पहले अगर आप इंडिया में आ गए हैं, या तो सीधा पाकिस्तान से माइग्रेट करके, या फिर आप इंडिया से गए और फिर वहां से माइग्रेट करके वापस आ गए. अगर आप इंडिया में आ गए हैं 19th of July 1948 के पहले पहले, तो आपको सिटीजनशिप डायरेक्ट मिल जाएगी. You will get direct citizenship if you have migrated to India from Pakistan before 19th of July 1948. On this date and after this date, you need to have a permit with you to enter India. Without that permit, you will not be allowed to enter India. That permit will be given by an officer appointed by the Indian government in Pakistan. And only upon knowing your intention to enter India for citizenship, not for some business, that the officer will provide you with the permit. That will be known as the permit for citizenship. And once you get that permit for citizenship, you can enter India, live here for 6 months, because before making the application for the citizenship, you need to reside in India for 6 months. Or else somebody can migrate from Pakistan to India, live here for a week and give the application saying that I want to be citizen of India, and then can go back and live wherever they want. To avoid such a case, one more clause was added that you need to live here for 6 months before you make an application for the citizenship of India. 6 months you have to be here. So person who were migrating to India after 19th of July 1948 have to have a permit with them, and when they come here they need to stay here for 6 months in order to become the citizen of India. Now, why this date, 19th of July 1948? What is so important about this date? So, an ordinance was passed during that time. The ordinance was known as the Control of Influx of Population from West Pakistan, Ordinance 1948. Control of influx of population from West Pakistan, because there were too many people coming from that area. There was no security on the borders. Anybody who want to enter can enter. The law and order condition was very much in dire. It was not proper. There were very less people just to inquire whether you are the citizen of India or not. Many foreigners also entered India through that route without permit. So in order to stop this influx, the huge influx of population from West India, an ordinance was passed and a cut-off date was given that after 19th of July, and this was enforced, this ordinance was enforced on 19th of July 1948. So that was the date. It said that after the enforcement of this ordinance, whoever enters India for the purpose of getting the citizenship has to bring a permit from the officer appointed by the Indian government in Pakistan. So very simple. 19th of July 1948 was the day on which the ordinance was enforced. What was the name of the ordinance? Control of Influx of Population of People from West Asia. So that is why this date is mentioned in the Constitution, 19th of July 1948. If you are coming before this date, automatically you will get the citizenship. If you are coming after this date, you need a permit. This is how the migration goes on. Then comes the registration. This was a chance given to all the people whose parents were born in India, or either of any of their grandparents were born in India, but they were not born in India. They were also not living in India. For example, somebody who went to the United States or to the United Kingdom or to Argentina or to any other country, and their forefathers lived in India, if their grandparents lived in India, if their parents lived in India, but they are not residing in India, it was a chance given to these overseas citizens of India to claim for the Indian citizenship through registration. What was the clause? It was very simple. If you want the citizenship of India, and if your parents, either of your parents or any of your grandparents from the mother's side or the father's side, if they were born in India, then you can claim the Indian citizenship. And how would you do that? You can go to the diplomatic mission or to the consular mission which India has in whichever country you are residing in, and register yourself there. Register yourself with the consulate or to the diplomatic mission which India has in the United States or United Kingdom or Argentina or Brazil, wherever you are living, or in Jamaica. So this was a chance given to the overseas citizen of India to claim the citizenship of India. These were the people of Indian origin who were not living in India, who were born outside. But if they really want the citizenship of India, this was their chance. So I hope you have understood that on 26th of January 1950, the people who were domiciled in the country, the people who were migrated in the country, and the people who could become the citizenship by registration were the citizens of India. ये 3 भागों में बटा हुआ था अपना citizenship. जो भी लोग यहाँ पे domiciled हैं, मतलब यहाँ पे पैदा हुए हैं, उनका माता पिता का जन्म यहाँ हुआ है, या फिर वो यहाँ पर रिसाइड कर रहे हैं 5 साल से ज़्यादा के लिए, या फिर जो पाकिस्तान से इंडिया आ गए हैं, या फिर जो बाहर रह रहे हैं बट उनने अपने आप को रजिस्टर करवा लिया एज एन इंडियन सिटीजन. All these people were the citizen of India at the commencement of the Constitution. अब अपन जो बात करेंगे वो 26 जनवरी 1950 के बाद की करेंगे। अभी ये जितने भी लोग हैं जो इन तीनों वजहों से इंडिया के सिटीजन बने हैं वो 26 जनवरी 1950 के दिन बने हैं। आई होप दिस इज क्लियर। कॉन्स्टिट्यूशन के आर्टिकल 5 से लेके 11 इसी के ऊपर हैं। ये आर्टिकल 6 बोलता है, ये आर्टिकल 5 ये बोलता है, 6 ये बोलता है और 8 ये बोलता है। अंडर आर्टिकल 8 रजिस्ट्रेशन, अंडर आर्टिकल 6 through migration and article 5 through domicile you will get the citizenship of India. आर्टिकल 7 क्या बोलता है? 5, 6, 8, 7 भी तो कुछ बोलता होगा। सो आर्टिकल 7 बहुत सही है। आर्टिकल 7 टर्मिनेशन की बात करता है। आर्टिकल 7 says that if anybody who has migrated to Pakistan after 1st of March 1947 will cease to be the citizen of India. Article 17 says that whoever who have migrated to Pakistan after 1st of March 1947 will cease to be the citizen of India. अब now comes the confusion. आप यहाँ पे कह रहे हो कि 19 जुलाई 1948 के पहले पहले जो भी आ जाता है उसको सिटीजनशिप दे देंगे, उसके बाद जो आता है उसको परमिट लगेगा। और यहाँ पे एक नई डेट लिख दी है, बोल रहे हैं कि 1 मार्च 1947 के बाद जो भी यहाँ से गया है उसकी सिटीजनशिप निलंबित। So in UPSC in our studies we do find the citizenship topic quite confusing. We always feel that there are too many dates given, which date is the cut-off date, but these are the only 2 dates you need to remember. ये वाली डेट तो आपको याद है ही है, 26 जनवरी 1950. This was the day our constitution came into force, the date of the commencement of the constitution. So I don't think so. This is something which you have been reading since you were a child. So I don't think so you have problem in recalling this date. So the 2 dates which are important for you to understand is the 19th of July 1948, on which date the ordinance for control of influx of population from West Asia was passed. West Pakistan was passed. 2 Pakistan थे ना उस समय, East Pakistan which has now became Bangladesh after the 1971 war, and West Pakistan was the present day Pakistan. So West Pakistan से जो population enter कर रही थी उसको रोकने के लिए ये ordinance पास हुआ था। 19th of July 1948 को पास हुआ था। यही कारण था कि ये डेट को कॉन्स्टिट्यूशन में मेंशन किया गया। एक दूसरी डेट मेंशन की हुई है, वो है 1 मार्च 1947। इस दिन के बाद जो भी पाकिस्तान गया उसकी सिटीजनशिप टर्मिनेट। वो नॉट अ सिटीजन ऑफ इंडिया, he has gone to Pakistan or she has gone to Pakistan after 1st of March 1947 and ceased to be the citizen of India. But think about one situation. If they have gone after this date, and what if they decide to come back? Second condition, if they have gone before this date, and what if they decide to come back? इस डेट के पहले पहले अगर आप वापस आ गए घूम के फिर के आके तो आपको नेचुरल सिटीजनशिप मिल जाएगी। अगर आप इस डेट के पहले गए थे तो आपकी सिटीजनशिप को टर्मिनेट नहीं किया गया था, बट अगर आप इस डेट के बाद गए थे देन यू वर सीज्ड टू बी द सिटीजन ऑफ इंडिया। सो टू मेक इट मोर सिंप्लीफाइड, if you have gone to Pakistan, if you have migrated to Pakistan on 1st of March 1947, and if you are willing to come back, then if you come back, before 19th of July 1948, you will automatically get the citizenship. But if you come back after 19th of July 1948, you need to have a permit. मतलब इस डेट के बाद जो कोई भी उस रास्ते से इंडिया में आ रहा था, they were not the citizens of India. That is why this ordinance was passed कि भाई उस जगह को वेस्ट पाकिस्तान से जो इन्फ्लक्स हो रहा है पॉपुलेशन को, दे आर नॉट द सिटीजन्स ऑफ इंडिया, सो यू हैव टू जस्ट स्टॉप देम फ्रॉम कमिंग. 1948 19th of July को people who were entering from Pakistan, they were the citizen of Pakistan, but were coming here to seek for the citizenship of India, and that needs to be allowed. Also, the people who have gone out of India to Pakistan were also ceased to be the citizen of India, and while they were coming back, they wanted the Indian citizenship. That's why they were coming back. So we have come up with the two provisions that if you come up to India before 19th of July 1948, you will automatically be given the citizenship of India, but after 19th of July 1948, you need to have a permit with you. All the powers to decide the matters related with citizenship will be the power to decide for citizenship and to make law on citizenship under Article 11. Under Article 11 have been given to the Parliament. The Parliament is empowered under Article 11 to make any law related to acquiring of citizenship or termination of citizenship, related to Commonwealth citizenship, related to dual citizenship, whatever way of citizenship, only Parliament has the power to make laws on it. This is what Article 11 says. Article 10 also says that Parliament has the power to make any changes from Article 5 to Article 8. That even if it is mentioned in the Constitution that through domicile, through migration, through registration, you can come to India and acquire for this citizenship, and it is mentioned in Article 7 about the termination of the citizenship, the Parliament under Article 10 has the power to make changes or to amend these articles. This is what is written in article number 10. So I hope this thing is clear that at the commencement of the Constitution, who are or who were the citizens of India. Similarly, Article 9 talks about dual citizenship, which is not permitted. So Article 5, 6, 7, 8, 9, 10, 11. This is the part second of the Constitution. Part second of the Constitution, which is on citizenship. Article 5 says that you can become citizen of India through domicile. Article 6 says you can become citizen of India through migration. Article 7 says that if you go out of India, migrate from India to Pakistan on 1st of March 1947, your citizenship will be terminated. Article 8 says that you can become the citizen of India through registration. This is a chance given to the overseas citizens of India. Article 9 says that dual citizenship is not allowed. Article 10 says that Parliament has the power to make changes in Article 5 to Article number 8, and Article 11 empowers the Parliament to make any provision for the future of citizenship in the country. So I hope this part of citizenship is clear to you. If you have any question, you can ask me. This is the provisions we had in our Constitution at the commencement of the Constitution for the citizenship, that on 26th of January 1950, who all will be considered as the citizen of India. 26 जनवरी 1950 के बाद कौन कौन सिटीजन है, कौन नहीं है, सिटीजनशिप कैसे अक्वायर करनी है, सिटीजनशिप को कैसे टर्मिनेट करना है, ये सबका सब पार्लियामेंट बाय लॉ डिसाइड करेगी। अब पार्लियामेंट 26 के बाद 27 जनवरी 1950 को एक लॉ बना दे या फिर 5 साल वेट कर ले, ये पार्लियामेंट के ऊपर है। सो पार्लियामेंट ने क्या करा, लॉ 1955 में पास करा आफ्टर 5 years. So the parliament and the government at that time was criticized because of it. So now let us come to the Citizenship Act of 1955. The Citizenship Act of 1955 बहुत सारी चीजों के बारे में ये बताता है। How can you acquire, how can you acquire the citizenship? How can you seize, cessation of the citizenship, termination or deprivation, termination of the citizenship. Talks about dual citizenship also. After it was being amended in 2003, when the overseas citizen of India card was allotted, they were not full-fledged citizen but the citizens of Indian origin. It also talks about the citizenship of the Commonwealth. Means whoever wants to become the citizen of India and the citizens and the people are from the Commonwealth countries, how will they acquire the citizenship of India? This is also been looked after by the Citizenship Act. So it is a comprehensive document on everything related to the citizenship in India. So how can you acquire citizenship in India by the 1955 Act? Through birth. Now whatever we are talking about here is after 26th of January 1950. 26 जनवरी के दिन 1950 में कौन कौन भारत का नागरिक था, ये बात इधर हो गई है। अब 26 जनवरी 1950 के बाद भारत का कौन कौन नागरिक है, वो बात इधर होगी। Whoever is the citizen of India after 1950 26th of January, this act takes care of it. आज भी जो भी सिटीजन हैं इंडिया के, तो ये एक्ट अमेंड हुआ है अलग अलग जगह पे, बट इट इज टेकन केयर ऑफ ऑल द सिटीजनशिप इश्यूज इन इंडिया. सो बाय बर्थ, बाय डिसेंट, by registration, by naturalization, and by incorporation of any territory into India. By incorporation of any territory into India. So by birth, if you are born in India, you can be the citizen of India. How simple. If you are born in India, you can be citizen of India. और फिर तो इस तरह से मान लीजिए एक टूरिस्ट कपल इंडिया में आया और उन्होंने यहाँ पर एक बालक को जन्म दिया, he will also be the citizen of India. If you are born in India, you are citizen of India. So is it allowed? These are the little nuances this act has, that who needs to be allowed and who needs not to be allowed to be the citizen of India. So you can be citizen of India after the commencement of the constitution. Okay, if you were born in India and if either of your parents were born in India, but there is also an exception given. If somebody's father is on diplomatic mission here, फॉर एग्जाम्पल काउंसलेट्स हैं इतने सारे, एम्बेसीज हैं इतने सारी, उनकी फैमिलीज भी यहाँ पे रहती हैं. फॉर एग्जांपल द एम्बेसी ऑफ द यूनाइटेड स्टेट्स और द हाई कमीशन ऑफ द यूनाइटेड किंगडम और ऑस्ट्रेलिया और कनाडा और एनीथिंग, their families also live. They are on the diplomatic mission here. So the children born to them will also be considered as a citizen of India? No, this is the exception. No. Second thing, if any part of India is under occupation by the enemy and you are born to the parents, your parents are the enemies who are occupying that part, then will you be considered as a citizen of India? No. In the occupied area, if you are born to enemies, you will not be considered as the citizen of India. So with these two exceptions, anybody who is born in India will be the citizen of India. Okay. Now comes descent. When we talk about descent, that simply means that they are not residing in India. So if they are born outside the country, they are born outside India, but either of the parents were born in or were citizens of India or citizen of India, then they can acquire the citizenship through descent. If they are not born in India but their parents are the citizens of India, they can acquire the citizenship through descent. अब जो इनके जो पेरेंट्स हैं, अगर उन्होंने भी सिटीजनशिप डिसेंट के थ्रू ही पाई है, मतलब वो जनरेशन से ही किसी विदेशी देश में रह रहे हैं, बट इंडिया की सिटीजनशिप उन्हें मिलती जा रही है थ्रू दिस डिसेंट वाला क्लॉज, थ्रू डिसेंट यू कैन acquire the citizenship of India. Then if you are born to such parents who also became the citizen of India through descent, then they have to go and register your name with the Indian consulate, with the Indian diplomatic mission in that country. Until and unless they do that, you will not be the citizen of India. Or third clause is, if you are born outside India but your parents are in the Indian government service, then also you will be considered as citizen of India. Foreign services में कितने लोग रहते हैं who have gone to different countries? So this is one of the way by which through descent you can become the citizen of India. That simply means descent का मतलब ही है कि your parents were of the Indian origin और आपको वहाँ से citizenship मिल जाती है. Then another important topic is registration. How you acquire the citizenship through registration? It's simple. You just register yourself. Oath of allegiance. Needs to be made. Oath of allegiance that I want to become the citizen of India and please allow me to do so, and you will be given the citizenship of India. But who will be given? Person who are ordinarily residing in India. Ordinarily residing in India. So in the previous slide we have seen that there were people who have came to India and became the Indian citizenship, and many of them have migrated, and on 26th of January 1950 these people were the citizen of India. But there were many people who were not given the citizenship but still residing. A huge population of migrant laborers who came from Pakistan were not given the citizenship, and from 1950 till the Citizenship Act came in 1955, they were not giving the citizenship. So this Citizenship Act of 1955 came up with a clause registration in which the first provision was made, which was that people who are ordinarily residing in India and their forefathers were born in undivided India, means when there was no Pakistan, the whole India was same, and they are ordinarily residing in India, means after when Pakistan was made, they have crossed the borders and are now living in India. They will be given the citizenship through registration. They will be given the citizenship through registration. Another kind of people were who were not born in India, but their forefathers were of Indian origin. They can also seek citizenship through registration. Then wife of Indian citizen can also acquire registration citizenship through registration. The only thing they need to do is to make a oath of allegiance. Then again, minor children of the Indian citizens, they can also acquire citizenship through registration. These are all people who are not living in India but want the citizenship. भाई आपने किसी से शादी कर ली who is not a citizen of India. एक लड़के ने शादी कर ली, let's say the girl was a citizen of the United Kingdom. और फिर क्या होगा? Through registration, the wife of the Indian citizen can get citizenship of India. अब आपने शादी कर ली, आप ब्रिटेन में रह रहे हैं, आपके बच्चों का क्या होगा? माइनर. They can also get the citizenship of India by registration. And last, the citizens of Commonwealth nations. If any of the citizens of the Commonwealth nations want citizenship of India, they can take the citizenship of India through registration. रजिस्ट्रेशन का एक प्रोविजन है जिससे कॉमनवेल्थ नेशन के सिटीजन्स जो हैं वो इंडियन सिटीजनशिप ले सकते हैं. बट इधर एक कंडीशन है, देयर इज अ कंडीशन अटैच्ड टू इट. द कंडीशन इज सिंपल, दैट देयर कंट्री मस्ट अलाउ द इंडियन सिटीजन्स टू बिकम सिटीजन थ्रू रजिस्ट्रेशन. एंड इफ देयर कंट्री डू नॉट अलाउ इंडियन सिटीजन टू बिकम सिटीजन्स थ्रू रजिस्ट्रेशन, India will also not allow them. For example, Australia is a member of Commonwealth, and if it doesn't allow Indians to become Australian citizens through registration, then India will also not allow Australian citizens to become Indian citizens through registration. So बराबर गेम होना चाहिए. हम आपको सिटीजन बनने के लिए अलाउ करेंगे थ्रू रजिस्ट्रेशन इफ यू आर फ्रॉम द कॉमनवेल्थ नेशन, बट फिर आपकी कंट्री भी हमको अलाउ करना चाहिए सिटीजनशिप बनने का, सिटीजनशिप लेने के लिए थ्रू रजिस्ट्रेशन. I hope these things, these are the 5 heads under which the whole citizenship through registration provision is based on. Then comes naturalization. Think about a person who is not from the Commonwealth of Nations and wants the citizenship of India. So through naturalization, they can take the citizenship of India. Also, there are other provisions inside this naturalization, and the other group of people, if they want the citizenship of India, they can take it. A person who has been residing in India from 7 years, out of those 7 years, he has worked for the government for 4 years. And before applying for the citizenship through naturalization, he has been working for the government from 12 months, can also seek for the citizenship of India through naturalization. So all the people who are not in the Commonwealth of Nation and wants the citizenship of India can acquire it through naturalization. There are several clauses to it. You need to live in the country for 7 years continuously, and before making a application, you must be here for about 12 months continuously. Then comes another provision, which is incorporation of territory. If India incorporates any territory in its neighborhood or a distant neighborhood, the parliament is empowered to give citizenship to people who are residing on that territory just by the virtue of their link with this territory. अब इतना बड़ा इंडिया है, लेट्स से कोई एक टापू इंडिया ने इनकॉर्पोरेट करा इंडिया के अंदर, अब उस टापू पे 50,000 लोग रहते थे, उन 50,000 लोगों का क्या होगा? Can they become the citizen of India? Yes, if the parliament decides so, they can become the citizens of India. क्या basis है? Their link with that island. So this is how the citizenship thing works. In 2003, dual citizenship concept also came up when the act was amended, and whoever the people who were of Indian origin who were living in foreign countries were given the OCI card, Overseas Citizen of India card. What did this allow? See, if you have to come to India after a particular period of time, you have to go to the police station to report all those little nuances and little difficulties which people used to face. They were all eliminated by this Overseas Citizen of India card. They were almost became half citizens of India. Only few of the categories were not allowed to them, such as they cannot fight elections in India, they cannot vote in India, they cannot become presidents and prime ministers in India, they cannot become governor in India, all these things, except every other facility which is given to the citizens were extended to Overseas Citizen of India. In the recent Constitutional Amendment Act, Citizenship Amendment Act of 2019, a provision is made for OCI that they can lose their OCI card if they are found in any sort of illegal activity in India. If they are doing any kind of illegal activity, major or minor offenses, then their OCI card holdership can be taken back. This is the dual. Then Commonwealth citizenship we have already seen. So if somebody voluntarily takes the citizenship of another country, he will cease to be the citizen of India. But that will be decided by the parliament, whether to take the citizenship of that person or not. Also, during the war time, if some person is helping the enemies, if somebody acquires the citizenship in India through naturalization or registration, and within 5 years he have been imprisoned for 2 years, 2 years of imprisonment has been done within 5 years of him acquiring the citizenship of India. In such cases, the citizenship can also be terminated. Their citizenship can be snatched from them. If you are residing outside India from 7 years continuously, then also in such a case your citizenship can be terminated. So this is it, and we just want to see a little bit of CAA, Citizenship Amendment Act. So Citizenship Amendment Act, there has been huge controversy over this Citizenship Amendment Act. What does it do? Citizenship Amendment Act give amnesty to 6 religions, from 3 countries, and their citizenship application can be fast tracked. They can immediately get the citizenship of India. So the Indian government says that the purpose of this legislation is to help the persecuted minorities in these 3 countries. Which 3 countries are these? It is Pakistan, Afghanistan and Bangladesh. From Pakistan, Afghanistan and Bangladesh, if any person who is from the persecuted minority, now Hindus may be in minority in India, but not in Pakistan, not in Bangladesh, not in Afghanistan. So Hindus are minorities in those countries. So are Christians, so are Buddhists, Parsis, Jains. So these 6 religions, Hindus, Buddhists, Parsis, Jains, Christians. Which one is left? Except Muslims, 6 religion. There are 6 of them. Which one is left? Sikh, yeah, and Sikhs. So Hindus, Buddhists, Parsis, Jains, Christians, and Sikh. These are minorities in Pakistan, Afghanistan, and Bangladesh. And if they are persecuted in those countries, they can seek the Indian citizenship and they will get the Indian citizenship immediately. It will be in a fast track thing. So what is the controversy around it? Several people say that if this legislation is based on giving amnesty to the persecuted minorities, and if you are really talking about minorities, then why not to include Ahmadis and Rohingyas into it? These are also persecuted minorities, although they are Muslims. Ahmadiyas are minorities in Pakistan, which is persecuted. Rohingyas are minorities in Myanmar, which are persecuted. But why are you removing one religion, Islam, Muslims, from this list? This has been the hue and cry of the whole case. So there have been anti-government protests in India. Also, it has been told by many political scientists that this legislation hurts the secular character of the country. India, being a secular nation, must not come up with any legislation which discriminates, or we shall say makes the faith or religion as the basis of citizenship. So this has been the major argument from the other side, that religion or faith must not become the basis for citizenship, and if you are providing amnesty to the persecuted minorities, then why not provide to Ahmadis in Pakistan and Rohingyas in Myanmar? That will settle the whole issue. So this is all about citizenship, which we have to see for your upcoming examination. And if you have any doubt, you can ask the question. Karan Negi is saying hello sir, but there's another request. He is saying that, sir, please make me understand in Urdu. I don't think I can speak in Urdu. हिंदी मैं बोल सकता हूँ, इंग्लिश में बोल सकता हूँ, बट उर्दू तो नहीं आती है. तो आप शायद हिंदी में समझ सकें. मैंने बीच बीच में काफ़ी चीज़ें समझाई हैं. इसके अलावा टॉपिक से रिलेटेड अगर आपके कोई क्वेश्चंस हैं तो यू कैन डायरेक्टली आस्क मी. So I hope let's end this topic here. We have studied preamble, we have studied the importance of Article 12 and 13, which defines state and law. Now we have completed the citizenship part also. Now we are going to come up and study about the fundamental rights, then the directive principles, and then the duties, and so on and so forth. We'll go and complete all our polity in the coming time. As you all know, the prelims examination has been postponed from 26th of May 2024 to 16th of June 2024. So you have got extra 20 days to prepare for it. I hope you all will do best according to your ability. And also we are coming up with the same sort of live classes for history subject that will start at 5 p.m. in the evening. From 5 p.m. you can join directly live session on history. I hope you enjoy this lecture. You have enjoyed it and you have learned from it. Any question, any query you have, you can post in the comment section. Thank you.